Hi, it's Mike DelSignore. Today's video I want to talk about whether you should hire a private attorney or represent yourself when charged for OUI. I'm Michael DelSignore. I've been an attorney in Massachusetts since 2001. I've been handling OUI cases all over the state of Massachusetts, and I want to tell you what I can do for you as an attorney versus the difficulties you might face if you just try to handle it yourself. You certainly can handle it yourself. The law gives every person the right to represent themselves. It's actually a constitutional right to represent yourself, but whether it's a good idea is certainly another question. And when you go to an arraignment, many of the judges will sort of try to discourage you from representing yourself because we've had a lot of training, and whether it's hard to duplicate that. So a couple things. So when you represent yourself, you're held to the same standard. You're supposed to know the same legal rules. And as a practical matter, as an OUI, the reason some people think they're going to represent themselves is they'll read the report and they'll think, well, I'm guilty. There's nothing I can do about it. I know I'm intoxicated, and I might as well just admit to the charge and not pay the lawyer. Certainly a sensible course of action. You can actually call me, and I'll give you my opinion, even if you don't hire me, and say, you know what, if you want to represent yourself, that's fine. You can, or this, you really should think twice about this. So I certainly review a lot of reports to make and give people advice all the time, every day over the phone. But here's some of the reasons why it's a bad idea to represent yourself. One, the police report. For someone who's never read an OUI police report, you're going to think every report is bad. I read a lot of reports from people that are crying, they're upset, and they don't know what to do, and I tell them, really, this isn't a bad report, that this is a good report, that in the scope of things, there's a lot of things we're going to be able to get out of the officer at trial that's going to show that you're not under the influence of alcohol. So while the generic things like odor of alcohol, slurred speech are in most reports, I'm looking for things that are not in the report. It's hard for you to know that without having, I've gone to some trainings all over the country. I've read pretty much every book there is on OUI. I've written a book for Massachusetts OUI defense, and I've spoken to attorneys in Massachusetts and in other states on OUI defense. So it's hard to duplicate that. I'm a better attorney now than I was 5 years ago, and you know, we're constantly learning and improving. So I look for stuff that's not in the report, and you're not going to be able to anticipate that. So when I look at a report, the way I look at it is I'm looking like, how is this officer going to testify at trial? What are they going to have to acknowledge? So the way it works is the more things you do right, the closer we get to reasonable doubt. So I'm taking every little thing that you do right that somebody who's intoxicated would probably do wrong, and I'm going to argue to the judge or the jury that that's a sign that you weren't impaired. There's some big ones. Obviously, the driving's a big factor. We want to minimize bad driving. We want to look at the area. We don't want to just take the officer's report at face value. I had a case once. They said, the officer said, my client almost hit a tree, right? So it sounds bad. Yeah, you almost hit a tree. So if you read that, you read it quickly, casually, you might think, oh, geez, this is a tough case. Maybe we should resolve it. Almost hit a tree. You go to the scene, and it's not, the tree's not right on the road. It's a curb, then the tree. So at trial, my argument was it couldn't have been that close to the tree because he would have hit the curb. So when you look at the details of these cases, a lot of times it tells a different story, and that's just not a one-off. It's a lot of times where you go to the scene, you're like, that doesn't match up with the report. So you need to investigate these cases and there's no real rush. So there's no rush to take a plea. In other words, in Massachusetts, you plead to a first offense OUI, you get a continuance without a finding. You're going to get a continuance without, you can always get the continuance without a finding, basically right up until the trial starts. So there's no rush to accept a plea on your typical first offense OUI. You have time to think about it, to look into it. There's video evidence. So sometimes if you're representing yourself, you might not know which departments have video. I routinely file motions to preserve video. I know which departments have video. I even know the quality of video. I haven't done this so often. So, and I generally know how long each department will keep the video. So you want to make sure if there's video, you keep it. And then there's going to be parts of the video that we would edit and create like an edited version for the court. So in other words, we take this edited version, we show you walking in, taking your change out of your pockets, answering questions like mother's maiden name, father's name, date of birth, and we play that for the judge, and we argue that, geez, you don't look impaired in that video. Now, the part where you take the breathalyzer, we're going to exclude that because we'll do a motion to knock out the breath test. And if you refuse it, we'll exclude that as well because it's inadmissible. So we'll edit the video, take out any inadmissible parts of the video. Breath test evidence. Don't assume these tests are going to come into evidence. Last week I had one excluded from evidence. Have these excluded from evidence all the time. There's a lot of procedural requirements. They need certain documents. The DAs aren't really used to getting breath test evidence in. I would say most attorneys don't spend the time or the money that I've spent to learn about breath test evidence. So they see a breath test, they're happy to, take a fee, plea the person out, and be done with it and move on to the next case. That's not my goal. We certainly have clients that plea out, but our hope with every client is that we're going to win the case. You're going to be found not guilty. If someone takes a plea, a lot that could be in their best interest, and we're happy to do that and help that process and get them the best resolution possible. But ultimately, our satisfaction as attorneys is to give people second chances to avoid an OUI conviction. So when you represent yourself, you just don't have the knowledge of how things happen in court, how officers might testify in the legal procedure. So I see things in reports all the time, and I say, you know what, I could, a good chance I can get that excluded from evidence. So I'm not reading the report thinking that all this bad stuff is actually going to be heard by the judge. Last week as well, I got a statement suppressed where my client said he had 3 glasses of wine. It was after he was arrested. Before Miranda, he was in custody, and he was interrogated. And I had a hearing where I had the officer admit that, he questioned him prior to reading Miranda. Judge excluded the statements. So understand that the way the report is written, the way the trial will actually happen, could certainly be 2 different things. The other thing is these cases, people get arrested in courts all over Massachusetts. We have a lot of district courts. I go to district courts from Orleans to Ayer, to Dudley, Dedham, Stoughton, Attleboro. I practice all over the state, and I know these judges well. So what might be a difficult case in one court, it might not be so difficult in another court. There's a vast variety of how judges and jury pools interpret the standard of proof beyond a reasonable doubt, and that's the standard they have to meet. It's a high degree of proof to a near moral certitude. So keep in mind, these cases are crimes of opinion. Opinions can be wrong, and there's a lot of different ways to show that. So one of the things people will read in their police reports, they failed the field sobriety tests. The officers, it's going to come to that conclusion, but did you really fail? I know what they're looking for, and I know that a lot of times the report will indicate the tests weren't scored correctly. The 9-step walk and turn. A lot of officers think you have to literally click your feet together on that test. It's not required. Your feet have to be fairly close together, but there can be a half-inch space. You see it all the time. Didn't bang their feet together. And when you confront the officer, you can show that really they're not doing the test they're trained to do. You see reports, one-leg stand, person's asked to put their foot 6 to 8 inches off the ground. That's too high. It's just 6 inches off the ground. You see reports that are vague, where you don't know if the person actually picked their foot back up. So all these things can make field tests unreliable, and we can use that to challenge that evidence in court. So don't assume just because there's a field sobriety test and the report says you failed, that's the final word. We'll argue that, no, you didn't fail, you passed it. You did a lot of things right that the officer didn't give you credit for. The officer might not have accounted for the fact that you had a medical issue, that those cars whizzing by at the time. So all these things make field sobriety tests unreliable. I'll point out the flaws in the test. I'll point out that you're polite, cooperative, respectful, and ultimately what I want to do is show that you're a great person, that you hardworking, have family, perhaps children, a job that you care deeply about, and bring out your great qualities for whoever's deciding the case, judge or jury, because I think ultimately these cases are decided on the emotional connection that I can convey between who's ever deciding the case, and make that come true, that, you know, this is somebody that is a good person, worth fighting for, worth giving another chance, and worth upholding the constitutional standard of proof beyond a reasonable doubt. So I certainly think that in an OUI case, you should hire an attorney, at least consult with an attorney, because I think you're short-changing yourself. You might be pleading to a case that you could have won. You're not making an informed decision. I want everyone to make an informed decision. We're here to help do that. You can call, text anytime, 781-686-5924. My personal cell. It's never too early, too late to call. Feel free to reach out to me, and I'll be glad to explain my thoughts on any OUI case you have, whether first, second offense. We handle it all.